right, everybody, welcome back to Law and Crime. So busy day right now. First, if you want to continue watching the Scott Nelson penalty hearing, you can go to lawandcrime.com. It's currently underway, and the state is finishing up with their witness. We are about to go live in a different case. We're going to Tennessee. We're going to the Roy Coons trial. This is the man who's facing serious charges in connection with the death of Johanna Ortega. Let's go live. I believe this is the first witness of this trial, so let's go live. Okay. Now, Judge, did you just hear that? That is a big moment right there. They're reviewing the text messages from the victim to the mother, and she goes, someone is knocking on the door. I think it's the man that cuts the yard, and we believe the defendant was the one who was hired to mow their lawn. That's not good for the defense.
No, it's not. It's a good identification of the defendant in this case. And you know what, Jesse? It boils down to keep in mind, technology often is the way that law enforcement is able to then figure out who the accused is or should be.
Yeah, and those statements from a victim are always so powerful. I'm also joined here on set right now by Katrina Kaufman, an attorney here on Law and Crime. Now, let me ask you, Katrina, we saw the defense yesterday. They said prosecution, their case is not that strong. There's no eyewitnesses. They tried to poke holes in the DNA evidence. What did you think of their strategy?
I didn't see the material from yesterday.
Off the set, she's gone. Next guest. No, it's fine.
But I'm really intrigued with where this iPad testimony is going, and I had thought it was just a DNA case before, so I'm really interested in the fact that they seem to have had some evidence in the text message from the girl that it was in fact Roy Coons who came by that day. Right,
no, exactly. And Judge Ashley, this kind of evidence is strong. On top of the fact about what we know, he's had quite the rap sheet, doesn't he?
Yeah, he does. He does have a lot of criminal history. What's interesting to me, Jesse, though, one of his defense arguments is, hey, law enforcement did not do a comprehensive investigation in this case. They didn't even look outside of the trailer park area for someone who may have done this. So it's great to hear all this specific information from this witness about everything they did do when the defense is saying they didn't do enough.
Yeah, no, I mean, it's a good strategy. And Katrina, the fact that they haven't pointed to an alternative suspect, which we see in a lot of cases, they point the finger at somebody they can name and point to, that doesn't necessarily hurt their case, but it would have helped their case more.
Of course, yeah. If they could find another suspect that they could defer the attention to, that would really benefit them. But clearly they don't know who else to point to in this instance. They're just trying to get any evidence they can to show that it wasn't, in fact, the defendant who did the crime.
Yeah, and also we believe, Judge Ashley, there was no forced entry. What does that tell you?
Well, I think that means that she knew the person, that she let the person in, even if it was the person that mowed the lawn or someone that she was familiar with in that capacity. She thought that it would be okay to open the door when they knocked.
And coupled with what we just heard, not a great day so far for Roy Coons. Now, Judge Ashley Willcott, I know we have to sign you off. Thanks so much for coming on. We can't wait to have you back.
Thank you, Jesse. Have a good one.
You too. All right, we're going to take a break. When we come back, a lot more to cover. Okay, Katrina, was versus is. Was the defendant there? Then did he leave? Is that what the defense is trying to point to here?
Yeah, it seems like they're trying to point out that the daughter sent a text a little bit later, implying that whoever had come to the door had left. And then they're also trying to pick at the idea that it was a guy who mowed the lawn, but maybe a different guy who mowed a different lawn that she was referring to take attention away from this defendant.
Pretty good defense strategy right there. I mean, maybe they could say he knocked on the door. Doesn't necessarily mean he's the one who did this. Interesting. Let's go take a break, and we'll be right back live in Tennessee. Okay, welcome back, everybody. We're live right now in the Roy Coons trial out of Tennessee. Interesting case. What we've just heard was outside of the presence of the jury. This is a hearsay issue right now. The fact is, what's coming into conversation is this series of text messages between the victim and her mother right around the time that she ultimately is killed, where she says she hears someone knocking at the door and she thinks it's the man who takes care of the lawn or takes care of the grass. I'm paraphrasing here. The reason that's important is because Roy Coons, the defendant, was the one who was hired to do this, and it would seem to suggest that he's the one who knocked on the door and killed her. But the defense is trying to say this is hearsay. And what is hearsay? Hearsay is an out-of-court statement that is used to prove the truth of the matter. So it's out of court, and it's being asserted here to say that Roy Coons is the one who did this. Now, Katrina, this is always a complicated thing. The state is saying this is an exception. Can you explain this?
Yeah, basically they're saying that it's an exception either falling under excited utterance or state of mind of the victim at the time. And I mean, I think this was really relevant.
What does that mean exactly for our viewers?
So an excited utterance is sort of like a startling event and their response to it. And state of mind is explaining what was going on in the victim's mind at the time that the message was sent.
The whole reason we have hearsay is it reliable or not? Can you use it? And here they're saying, well, in these kinds of circumstances, you can rely on this. And the question is, this 12-year-old girl, what exactly does this fall into the hearsay exception or not? It's a little bit of a legal issue, but if the state can get this in, oh, this is a really big blow to the defense. Let's go back live. Okay, so we're about to see what the judge is going to rule here, and this is interesting. The state is saying, the defense is saying, there's no right to have these messages thrown in there whatsoever. What's your take on it?
I think that the messages should be allowed in. I think it definitely falls under one of these exceptions. I think especially the way the mother talked about how the children wouldn't normally text her, it shows that this was a really surprising event, and that's why she reached out. So I think it could fall under excited utterance. Even
though the defendant's saying he doesn't have a right, he can't cross-examine this witness about what was going on.
That's true, the victim's dead, but I think that these statements should be allowed in, and I'm curious what the judge has to say.
Yeah, I think they're going to go to a brief recess right now, and then the judge will have an opportunity to rule on this. It's an important motion, important determination here, because if a jury were to hear that, that is a big blow to the defense's case. So we're going to take a break on our end. We're waiting to see what happens. We're keeping a careful eye on Scott Nelson. A lot happening here on the network. We'll take a quick break. We'll be right back right after this.